Success is walking from failure to failure with no loss of enthusiasm by Winston Churchill. Now, keeping the quote in mind, let's get started with the session for the day. Good afternoon, everyone. My name is Isaac Franklin, and I'm a student at Andhra University Electrical Department. I will guide you through the agenda and proceedings of today's events. A warm welcome to all the speakers, guests, and attendees. Thank you for joining us today. Let's make the most of this occasion to engage and make meaningful connections. Before we begin, I request all of you to give yourselves an introduction. Starting from myself, I'm Isaac Franklin. I'm a student at Andhra University Electrical Department.
I am good. I am Murli. I will be speaking today on IPR, and I am from Novel Patent Services.
I am J. Hammond. I am from AEC Engineering College. I am studying EC branch and fourth year.
Myself Jidipka from Andhra University EC Department.
Good evening, everyone. Myself Sahil Tamudu. I am in BBA in Andhra University.
I'm Sanjana. I'm from Andhra University School of Business.
Happy evening, business enthusiasts. Happy evening, business enthusiasts. I am Reshma from AU Incubation Center.
Good evening.
I'm Haika, student at Andhra University from Department of Statistics.
Good evening to one and all. I am Pallavi. I am Department of Statistics from Andhra University.
Good evening, myself Meghna. I am student at Andhra University from the Department of Statistics.
Good evening. I'm Geeta from Statistics Department at Andhra University.
Good evening, I am Pragya Bhavani. Andhra University in the Department of Statistics.
Good evening. I am Jyotini and I am from Department of Statistics.
Good evening. I am Priya from the Department of Statistics at Andhra University.
Good evening to everyone. I am Nancy from Statistics at the Andhra University.
Good evening, everyone. I am Santoshi Vodala. I am from AU, Department of Statistics.
Good evening to all. I am P. Raghuroshni and I am from Statistics Department.
Hello everyone. My name is Sushmita. I am from Chemical Department Engineering.
Hi everyone. My name is Navin Sai. I'm co-founder and CEO of Tones Fashion and Ashpur Academy. Thank you.
Hello everyone. I am Rajasthan. I am student at Andhra University College of Engineering in Electrical Department.
Good evening everyone. My name is Suresh. I am from Andhra Pradesh near Vijayawada. I am a graduate and I am doing 4 years of research about different types of startups. I am here to come for something help from AF. I am expecting investors help from AF. Thank you.
Hi guys, this is Rajesh and I am currently pursuing CSC third year in Andhra University. Thank you.
Hello guys, myself Ramtes. I am pursuing BTech third year EEE.
Good evening, everyone. This is Prahash.
Hello everyone. I am Danesh. I am currently working as an operations executive at AHA.
Thank you. Here are a few ground rules before we commence the meeting. Kindly switch your mobile phones to silent mode. We request that you refrain from entering or exiting the session while a speaker is delivering the presentation. Please wait until the speaker concludes the session. Please refrain from engaging in crosstalk or side conversations. Kindly note that the startup pitch is allowed a maximum of 10 minutes, followed by a 5-minute Q&A session. We kindly ask all presenters to adhere to the allocated time to ensure a smooth flow of the event. Also, the idea pitches is allotted a maximum time of 10 minutes, 6 to 7 minutes to present and 3 to 4 minutes for Q&A session. We request that audience members reserve the questions for the designated Q&A session. With that, let us begin the Startup Start Day session. The primary objective of Startup Start Days is to inspire, motivate, and provide valuable assistance to founders. We aim to foster a supportive environment where insightful comments and helpful advice are shared among participants. Together, let us work towards nurturing innovative ideas and fostering entrepreneurial development. Without further ado, let me introduce one of the speakers for the day. Our featured speaker is Mr. Murali Krishna Patadi. With over 17 plus years of experience in the field of intellectual property rights, he is the Director of Novel Patent Services, Novel IPR Academy, and Managing Partner of Novel Innovation Design Studio. He is a postgraduate in biomedical and graduate in chemical engineering, complemented by certifications in IPR, Six Sigma, and TRIZ, making him a versatile expert in patent-related solutions and innovation strategies. Let's welcome Mr. Krishna Patadi with a round of applause. Welcome, sir.
अच्छा मुरली पट्टा दिया मुरली तो दिया
Sorry for the delay, guys. We'll give you back in session in 2 to 5 minutes, please. Mr. P. Lokesh from AK Innovations is present here.
most of you are new to this IPR, and a few are there who are very much aware of IP. Today we will be talking about, I'll be just giving you an intro about intellectual property rights. Most of you might be knowing, but just what is the need of IPR and different forms of IPR, and how exactly it is used in different kinds of strategies used by different startups. So a few examples of startups which actually had a very good IP strategy and they became successful. Of course, you might be knowing them, but still, I'll try to give from my side whatever is possible. And this is the most common slide you might be knowing. So first, what is intellectual property rights? Whatever we get from our brain, or whatever we design, or what we think uniquely apart from others, in whatever form you do, whatever comes out from your brain can be protected as intellectual property rights. So we need to decide in what form we need to protect our unique ideas. There are different forms of intellectual property rights. The one is patents, trademarks, copyrights, geographical indications, and industrial designs, trade secrets. We will not be going in detail about all these things, but we'll just know what is a patent. I think you might be knowing anything, whatever you invent, or what is not there, or when you try to solve a problem which is existing in a existing product or any solution or in any methodology, whatever we use. If you try to solve a problem, you will come up with a new idea or new technology or new solution where you can overcome that solution. If that is a unique thing and if it satisfies particular rules of patents, it can be protected under patents. And trademark, it is the most common thing, and you people know, and you are aware of different kinds of trademarks, different brands. In a common man's language, we call them as brands. But how do we protect? Everything can be discussed in detail when we go through trademark section, trademark part of the presentation. And when it comes to copyright, so whatever expression we give, when I'm trying to talk, when I'm trying to explain, if my explanation is different and my method of explanation is different, though everything is known to you, how do I explain to you can also be protected as copyright. Suppose, for example, the same Pythagoras theorem you will find in state syllabus textbook, CBSE textbook, and everything. But each and every textbook will be protected under copyright. So copyrights will be given only for expressions, not for unique ideas. When it comes to patents, patents will be given for unique ideas when you come up with new ideas which were not there till date. And you are the first person to come up with those solutions or those ideas, if you are the first person, you will be given a patent. But when it comes to copyrights, though it is not a new idea, and your method of expression is different, and how do you represent that information can be protected as copyright. Some of the examples of copyrights, most of you know, music, photographs, drawings, or even literary books, textbooks. All these books would be coming under copyrights. So because today I'll be taking you through in detail maybe a few more slides in patents, trademarks, and designs, but I'll not go in detail on copyrights or geographical indications or trade secrets. So we'll try to talk some more lines about copyrights. So in order to understand what exactly is a copyright, is to have a better understanding. When you both, let us say two people are walking on a beach road and early in the morning, and those two people have seen sunrise and they feel like it is very beautiful and the scenery is very good, so they want to take a photograph of it. and both had different cameras, and both captured the same picture with their own styles and with their own cameras. So they came up with different photographs which are very beautiful, and now you will get two different copyrights on each photograph. So because my way of expression, my way of capturing the image will be different, and the person who is coming with me or my friend who is coming with me, the way he captures the same sunrise, the same beach and everything, how does he capture will be different. Though the ingredients or the features whatever we capture might be the same thing, but how we capture and how we make it more beautiful will be protected under copyrights. In the same way, the same concepts, how do I explain, will be protected under copyrights in books and everything. So copyrights is a very big subject, and most of the times when you try to come up with different ideas, some people don't know that they won't check whether it would qualify for a patent or for a copyright. They generally go with copyright, and they generally go and publish, like they don't actually even protect copyright, they will generally directly go and publish in science journals like Elsevier or some Scopus, some kind of scientific books or magazines or something like that. And those, by default, those companies would provide you copyright protection, and of course, to whom those rights will be given, based on your agreement with those people, those will be decided. So naturally, like you need to decide. Suppose if you come up with a new idea, and you feel like this is unique, and you want to protect it, first you need to decide which form of IP would protect your idea. So when it comes to inventions which are not there till date and which are new to the world, will be protected as patents, and the expressions, though it is not a new idea, the method of expression is new, or it is very entertaining, or it is very catchy, or something like that, something very much interesting, all those can be protected under copyrights. So next, coming to geographical indications, it is like based on location. Like suppose for example, to understand easily, when we try to explain you, like Assam tea is there. Suppose if you take Assam tea, the flavor of it, the color of it, texture of it, all these things would have some special features when compared to other forms of tea when you get from different parts of India or different parts of any world, like world. So naturally, some people would be liking only Assam tea, and they would be preferring only Assam tea. So how do we protect, or how do we have monopoly of that, or how do we take advantage, or economically how do we take advantage of such kind of things? Is geographical indications is one of the solutions. Like suppose for example, I live in Nilgiri Hills, and if my someone likes my tea, and from Nilgiri Hills, so I can brand my tea under Nilgiri Teas, and those properties whichever would accompany with Nilgiri tea will be protected under geographical indications, and they can start selling it. So suppose for example, someone has grown some tea plantation in Aruku, and they want to sell it as Nilgiri tea. They cannot sell because there are some geographical indications, and there will be some taste differences between the tea which we grow in Assam or Nilgiri and the tea which we grow in Aruku. So based on all those things, for such kind of protections, geographical indication is the best solution what we can utilize. Suppose for example, it need not be speciality of the product only because of your environment. Sometimes if you consider tea, it might be because of environment. Maybe the soil is different, environment is like climate is different, and whatever other features which influence the product output, whatever we get from it. All those things would give some impact on the kind of product we get. So such kind of specialty products can also be protected under geographical indications. Sometimes what would happen is, it need not be only because of climatic conditions. Sometimes because of that place, by DNA, like some skill will be inherited in the people who live in that area. Like when we see some of the examples based on inherited skill, what we call as Etikopaka Bommalu toys, what we call, or even Kolkata Rasgulla. So people might be trying to prepare the same Kolkata Rasgulla here, but the flavor you get here might be different when compared to Kolkata. So the people who do that, because they regularly do that and they might be doing from their ancestors, and so they can get some flavor in it and they will get some very good taste in it, and people what people might like it. So even skill of the people based on their location, based on their inherited like because of their ancestors, whatever they inherit, can also be protected under geographical indications. So geographical indications can be protected based on like whatever products, like what we get based on the location, based on geography of from where it has originated, will be protected under geographical indications. Sometimes the product quality or the speciality to the product you will be getting based on climatic conditions. Sometimes you get the speciality in the product based on your inherited skill set you get from your DNA or your from ancestors. So all those will be protected under geographical indications. How do we protect, and all these things you will be learning in when you attend some other IPR conferences. Here we will just try to know different forms of IPR. That's it. The second one, the next one is industrial design. So whenever you come up with a new design to a product, existing product or any product, you can protect it as industrial design. Then what is the difference between a patent and an industrial design? Is in industrial design only aesthetic appearance of the product will be protected. The underlying utility or underlying purpose of it or problem solving solution will not be protected under industrial designs. So only the shape will be protected under industrial designs. Here if you see the same Coca-Cola bottle, the shape of it is protected under industrial design. And it protects only aesthetic appearance and it will not protect any functional or utility behind those designs or anything. Sometimes you need not have new utility because of this shape. Only the appearance, if it impresses people, they can build some brand and they can build value to their products. So those can be protected under industrial design. And when it comes to trade secret, and the earlier thing, if you take a Coke bottle, the Coke, whatever you are talking about, is the composition of Coke. It seems that it is a trade secret, and only a few people know the formula of Coca-Cola, and most of the people don't know what is the formula. But many people tried using reverse engineering technologies and many people said that this is the formula of Coke, but they did not acknowledge, yes, this is the my formula, and they still maintained it as a trade secret. So when we say what is a trade secret, like when we say the information whatever we try to protect, and based on our protected information, if we try to exploit the secret information and get advantage, economical advantage, or have an advantage in our business, that whatever information we protect it as a secret will be called as trade secret. Or any secret information which is protected would help us in building our business or giving an edge over others, over our competitors, will be considered as a trade secret. So any information which you keep it as a secret, but it helps you in building your business, will be considered as trade secret. So what is a trade secret? Sometimes the formula of a chemical composition can be a trade secret, and sometimes even you call invoices or pricing structure you give to your clients can also be a trade secret, and any algorithms you use, if you don't want to give it openly to the public, can also be protected as a trade secret. Most of the times making methodology or process will not be given to the public. All those would be considered as trade secrets. How do we protect those trade secrets? Is like it depends. Like if it is, suppose for example, if you want to protect information of it, like you will not give access to each and every people, like every person, like it will be restricted, access will be restricted to only certain people, and before giving it to even to the restricted people, it will be clearly given, like they will be given instructions that this is a trade secret information and you are not supposed to disclose to anyone else, and you got to have proper documentation stating that you are not supposed to disclose, and you need to have proper agreements, and everything should be in place before when we try to protect these trade secrets. Sometimes these trade secrets would help to build our business in multiple folds, and it is very very important how do we protect. There is no direct protection to the trade secret. Only thing what you have is how do you protect once it gets violated, or once someone takes away your trade secret. Only then, if you can prove before court stating that someone has stolen my trade secret, only then it will be considered as a trade secret, and court would evaluate whether this is a trade secret information or not. How does it evaluate whether this is a trade secret information or not? They have certain procedures. They would see that did you take care of protecting it, and what measures you have taken. Do you really have agreements to disclosing to different people stating that this is a trade secret information and you are not supposed to use it. All those measures did you take or not? They would examine, court would examine, and then they would consider it to be a trade secret, and based on their trials they would decide they really have stolen the trade secret information or not. And most of you know what is a trademark. So these are some of the examples of trademarks. And when you see TM, SM and R, when we say TM is like when I apply for a trademark, and if I design a different logo or a different name or coin a name, and if I want to protect it as my trademark or in the form of word mark or logo, then once I apply for it, it will be given as TM. So before going to that, there are two things in trademarks. One is word mark and the other one is logo. Suppose for example I come up with a name, like suppose for example if you take Novel Patent Services, I can protect it as a word mark as well as a logo. Logo means the pictorial depiction of your design, your logo or your business identity or mark, the mark which represents your business. So there are two forms of protecting your trademark. One is word mark, the other one is logo. In trademark office we call them as devices. So if we try to protect Novel Patent Services as a name, and if we can get trademark registration for that name, today I might be writing in a different style, and tomorrow you can write it in a different style. So I will be having exclusive right on the name or on the particular word. So I can write the name in different forms in whatever way I want, because I have right on that name. Suppose if you get right on only logo or on the design or on the picture, whatever you want to protect or you want to use it, then you will get right only on that. If you change colors of it, or if you change the style of writing of your business name, everything, then again you are not protected under trademark law. Someone can come and they can change the style of writing and they can easily use your trademark. So there are two different forms of protecting it. One is word mark and the other one is logo. So it's generally, if it is altogether a new word, if you are coming up with a new word to protect your business or to build your brand value, it is always advised to go for two kinds of protection. One is word mark as well as the style of writing. Because what will happen, suppose if we get a right on word mark, we will be having, like today our designers or our marketing team might decide that we will go with this style, but sometimes after a while when we go into the market, we might feel that we want to change the style of writing. Then if we change, again you will not be having the right on it. So generally what people do is they will try to protect it as word mark as well as in designs. But when do we go only with logos is, some name will already be there, and if you still wanted to use that, only thing is you want to extend beyond that. Suppose for example, my company name is Novel, and tomorrow you want to come with Novel IT Solutions, and if I don't protect it as a word mark, and someone has protected it as we might be protecting it as a word mark as well as a trademark, but our word mark is Novel Patent Services. Someone might have come up with Novel IT Solutions. So then for him word mark will not be granted, but if he comes up with a different logo and different style of writing, only for that logo they will be permitting, but name as such they will not be allowed to use, and they will not be given right on word. They will be given only on the design. So the initial person, like initial company which files on word mark as well as on design, like suppose for example Novel Patent Services, because I have protected it under word mark, someone will not be allowed to protect it, though the extensions of the name changes, like Novel IT Solutions or Information Technology Solutions are changing. Though it is changing, they will not be allowing them to have a trademark on it. Only designs will be allowed. So there are some different advantages of having both, and it depends, like based on your business needs, we will try to suggest you in what form you got to protect it. And when it comes to TM, SM and R, most of the times we see on different names of the boards, on boards we see on top right hand corner or some on corner you will be seeing like TM or an SM. When we write TM, it is still in application stage and we are not granted a patent. Sorry. When we write R in a circle, then it is registered. That means that company or that logo was granted to a particular company, and he has the right on that trademark. And when it comes to SM, some people want to clearly depict that this is a services company, and they can name it as SM when they are still in application stage. Like the trademark office will not be granting them till still it is in application stage, but it is not granted. People generally write either TM or SM based on what kind of service they are giving. Suppose if that company is under services, they will be writing as SM, and if that company deals with different kinds of products and everything, they can go with TM. Even some services companies can also use TM, because most of the people know what is TM, and they can though they get grant, still they use TM only because people can recognize that okay, it is protected. Only then they will be recognizing that still it is protected. If you write R, they might not be knowing what is R, but if you write TM, people would recognize it. So sometimes what will happen is, though it is granted, people will not change it to R. They still continue with TM. Normally, as per patent office law, when we write TM or SM, it is still in the application stage. Trademark office did not grant, and when we write R, it is granted. For 1 year or 2 years, they might allow. If you write like this, if someone complains, again they need to pay penalties to them. So these are different kinds of trademark protections. If you see, for a product you can protect it, for a service you can protect, for shape, even for the pattern also can be protected under trademarks, packages, everything, like even for certification mark, all those marks can also be group of industries. Oh. You know all these FFS, this is for food and this is for different kinds of services as well as the products. And general, if you see channel, these are some of the examples, like how counterfeits would come. All these are wrong, like all these are counterfeits only. These are not the originals. And if you see here, only Pulsar is the original one, and rest of the things are not original. And you know, in our Vizag itself, you have all these 5. KFC has registered long before, and now even these people are getting for these names, because trademark has some kind of statutes which states that if you have very good business and you have established in the business, and because KFC did not stop these people from using it, so they could get some registrations, like though Deccan Fried Chicken did not get, but DFC have come. Someone is using DFC, but it's not Deccan Fried Chicken. And McDonald's and McDowell's, if you can see, and even the trademark types, even the Taj, this is also a trademark. Even the shape of a building can be protected as a trademark. And what are the uses of a trademark? If you see, even a product or service can be protected, and you would build a brand. The moment you see a particular symbol, people would relate to the quality you get, the cost it would be, and the durability of it. Everything they can relate from where it has come and everything. So it creates some brand value to that. Based on that, people or customers would try to pick that product. And the main purpose of it is, if you see the same MFC, KFC and everything, if you have a proper trademark and if you have a proper strategy, you can stop your competitors from using your marks. And this is generally how exactly, if you define different kinds of trademarks, there are the kinds, how do you define? Like some people would define the trademark on their own, like they generally design on their own, like they mix different kinds of words, like let us say M from my name and some K from someone else, and they coin those words. Those will definitely get grant. And when it comes to arbitrary words, though they doesn't mean what they're building, their business is all about. You know all those names. For example, Apple is there. Before use, of course, if now it is a well-known mark. Before Apple was granted a trademark, Apple is known to everyone, but everyone knows only it as a fruit. Nobody knows that it can be branded for a company or to a product. After that, those are known things, but it's for a different kind of purpose they will be using it. And the other one would be suggestive words. By the time, the moment you see those words, people can sometimes expect that this product, based on that name, they can expect might be this is the product or this might be the service. So that is the reason they might have kept this. And the descriptive thing is, suppose for example, if I start a vegetable shop and if I name it as Green Groceries, naturally the name itself would tell me like what I am trying to sell. So these are called descriptive, and some are generic, they would try to sweets, Indian, like of course Indian sweets is there again, to some extent, even then it can be generic. So if you see the method of granting a trademark, this would be the thing. The first, you will not have any objection or opposition for the first one. When it comes down, like people will not be getting grants for these things. So when you name, based on that you can decide how do you do that. And when you get a grant for a trademark, it will be given for 10 years and you can renew it every 10 years. So based on your business. There are 45, the moment you want to protect your product under a trademark, you will have 45 classes. We need to decide in what class your business would fall. Based on that, you got to protect. There are 45 classes. In that, 35 classes would be on products and 10 classes would be on services. And now we know what is industrial designs. Industrial designs is all about aesthetic appearance or shape of a product. So you can protect even that. So you can protect a chair-like kind of thing. Here, what you are seeing here. And the purpose of it will not be protected. Even the comic characters can be protected under industrial designs. And if you see a clip or even a toy or the shape of a bottle, perfume bottle can also be protected under industrial designs. Here, the purpose behind why do we design that is not important to the industrial designs thing. It is only for artistic view and only to attract customers. Those unique designs which would differentiate your product from others would be protected under industrial design. So even the Apple store is also protected under industrial designs in US, not here. Some buildings can also be protected under industrial designs. they examine based on these three criteria. One is new, the other one is original, and it should have an individual character. First, new is it should not be there, like that design should not be used before, and you are the first person to use that new design. And the second one would be original, like you got to define and you got to design it based on copying, or you should not copy from others, and it should have a differentiating factor from your competitors. And when it comes to patents, we discussed like for inventions, especially it can be a chemical composition or a mechanical thing or any other products. When we solve a problem, when we try to define patent, like when we try to solve different, when we invent something, all those would be coming under protected under industrial design, patents. And you have products and processes can also be protected. Only thing is software as such. I see most of the people who have attended, like before many people have come, they introduced that they have come from statistics, and if you define a methodology, how do I calculate some kind of like how do I do survey or something like that, as such they cannot be protected. If I say that by using a app I can do a different kind of statistics or different kind of survey, those can be protected under patents. That we need to dig and we need to examine, and we need to say how do we protect that. By the moment you apply for a patent, it will not be protected. You got to request the patent office to protect it. And these are some of the important features of the patent office. And patent term is for 20 years. For trademarks it is 10 years, and for patent it is 20 years. And they would mainly examine on three features. One, it should be a new thing, novel, and it should have an inventive step. And the other one is it should have an industrial applicability. When we say new, it should not be there anywhere in the world. Like suppose for example, patents or any IP, any kind of IPR is a geographical right. Like suppose if I want to have right or monopoly on my technology or unique way of thinking in India, I need to file an application in India and I need to get a right here. If I want to have a right in other country, I need to file a separate application there and I need to get right from that patent office or trademark office or industrial design office. So it is a geographical right. It's not there is no patent like if you try to file a patent here in somewhere, and if I say that it is an international application, it will not be granted. You got to file wherever you feel that your product will have some kind of market. Only then you will go into those markets, and there you will be trying to file a patent. Suppose for example, you have invented a water heater or room heater, and you wanted to file for it. Suppose for that you don't find a market in Dubai, so there is no point in filing a patent application in Dubai, and you can file somewhere like in countries where it is too cold or where you have snowfall and everything. If you file there, you can definitely have a market there. So based on your marketing strategies, based on your market you have, you got to decide where do you need to file patent applications, and you need to file in those countries. Or any other IP right, you got to file in all those jurisdictions wherever you want to have. So it is a geographical right, so you got to file wherever you. So again, now when it comes to patent, it will be decided on three things. One is it should be novel, and the other one is it should have an inventive step, and the third one is it should have an industrial applicability. When we say novel, though I might be filing a patent application only in India and I don't want to file in any other country. Suppose if I want to have a patent here, you might say that nobody is using it in India. I am the first person to do or use or resolve that problem. Though you might be saying that if someone uses in Brazil or someone uses in any other part of the world, it will not be considered as novel. So for any patent, it should be novel. It should be new to the world. It should be new on the earth. And the other one is new means or what is an inventive step? Like for example, there should be a technological advancement to that. There should be improvement. Like you should solve a problem. We might be using the same components which are already existing. We might, yeah. we might be using the same components. How do we use it? How do we resolve it? If we are the first person to solve it, or if we are trying to reduce the cost of producing a technology, or if we are the process of making it, if you are trying to reduce the cost, all those would be considered as inventive steps. The first one is the idea should be new to the world. The second one is it should have an inventive step. For that we need to have a separate session for it to understand what is an inventive step. This is common process. Once you file a patent application, you will have publication. You need to apply for a request for examination. Then they will examine and they will give you a FER, and then we need to reply to that, and then they might grant. After grant, you got to maintain your application for 20 years. You need to pay fees. And suppose if you want to file in different countries, how do we file? These are the different types of filing. Either you can directly go to those countries, or you can file it using a PCT application. Suppose if you take a product, there are different kinds of protection for a single product. You can protect it as the technology, whatever you define, can be protected as patent, and the brand of it can be protected as trademark, and the material which discusses how does it function or how to use, all those materials which help customer to use will be protected as copyright, and the design or appearance of that product will be protected under industrial design. So a single product can have n number of multiple kinds of protections, IP protections. And this is one of the Indian startup which actually because of IP strategy, of course, because of other things also, but with proper IP strategy, this is an Indian company which actually grew up, and now it actually the value of the Joho company is more than $1 billion, and it has more 60 patents till date, and most of them were granted. And this is SpaceX company. You know, everyone knows about this company, and they have 143 patents, and because of course they believed in research, and of course other strategies, marketing strategy, how do they brand, and where are they working, all this also help to increase the value of that company. But patents or IP strategy, because of proper IP strategy, they could survive, or they could maintain that monopoly in that industry. So this is one of these are some of the examples. If you have any other doubts, I can tell you.
Anyone again ask questions if they have any queries?
How long does it take to get a trademark?
1 year. The moment we apply for a trademark, if the trademark office doesn't have any objection, they will advertise that application for 120 days. And in that period, if nobody opposes your application, it will be granted. So normally it should take 6 months, but generally it would take minimum 1 year. For patents, it would take, on an average, if you go on a normal pace, it would take 2.5 years. But for startups and lady inventors, these days we are getting even within 1 year.
Thank you, Mr. Vijay Garu, for the time.